All right, let's see who all we have on now. All right, people are slowly starting to add. For anyone that's on that can hear me now, we're going to give people about 5 minutes to show up. If you would like to ask any questions, and I'll reiterate this again here in a little bit, feel free to put your question in the chat. We do have Drew Travis in our Austin office that is monitoring the chat and will update Jason so that at the end of the Q&A, we have everything ready to go. So Jason, how has your Tuesday morning been going so far?
Tuesday morning's been fine. Got the kids off to school. It's Eric's week to be student of the week, so we have to provide pictures and all that type of stuff so he can explain his life to the kids in his class. It's very interesting because for those of you who don't know, I have triplets, and my kids don't understand that most other kids are born one at a time. So they have a hard time sort of explaining it to other kids. I guess it just seems normal to you. So,
well, I'm an Irish twin, so pretty close. My brother, who, I mean, I don't know what tricks genetics are playing on us, but my brother's 6'3", and I'm 5'10".
So you're the Danny DeVito from Twins, basically, and he's the Arnold Schwarzenegger.
Now, Danny DeVito was like 5'8", or less, maybe 5'2" or 3". No, I would not play the Penguin in a Tim Burton film. Well, maybe, I don't know. I would do anything Tim Burton asked. But
there you
go. So triplets, that has got to be. I mean, I think you should write a book. Would they? Maybe this is a little too personal, but were they natural?
Yeah. It's funny because people come up to me all the time, and my wife, and they say, did you plan that? And I always think, how would you plan that? Like, even if you were crazy enough to just say, I'm going to have triplets, like the ability to sort of pull that off just from a practical perspective is
on the first round.
Yeah, very, very difficult. So no, that did not. They were not planned. I just remember going into the doctor and him saying, "This is impossible," and we're like, "What?" We thought something was wrong. He's like, "There's 3 of them in there," and I think I deal with stress by laughing, so I kind of started laughing, which my wife always mentions that she saw her life flash before her eyes, and I was laughing, and I don't think I slept for about 2 weeks after that because your whole life's about ready to change in ways you can't even imagine. So.
See, I would have assumed that you would have gone black, woken up in a hospital bed 24 hours later, highly sedated. Sir, you had a heart attack.
Yeah, that was my wife. I think I was just laughing to deal with the stress, but yeah, it was an interesting time, But they're great now. They're in first grade. They're 7, and they are just fighting all the time about everything, which is what apparently first graders do. So they fight about whether or not they're fighting. So
have you looked into the boxing gloves? Because when we were kids, the 16 ounces were good. You know what I mean? You could no physical damage done. You know what I mean? Like, okay, boys, go in the back. Because I'm one of 3 boys, and then we have a sister that came 12 years down the road. So needless to say, her boyfriends have a tough run of it.
Right. It is a nice thing with them all being the same age is when they do fight, we don't feel like we have to sort of, they can work it out. There's no size advantage. There's no age advantage. So
kind of like a pack of dogs.
They can sort of settle it on their own. There's no, hey, lay off your little brother type thing. We just
have you ever thought about
figure it out.
Putting a chalk circle in the backyard, putting one toy in the middle, and seeing who comes out victorious?
Okay. A new show, Triplet Death Match. Yeah, there we go.
Triplet Death Match. Triplet Fight Club.
Yeah.
All right, guys, we are at the 5-minute mark, so we're going to go ahead and get started. I hope everyone can hear us. This is going to be more of a conversation as opposed to a straight presentation. Those of you that know Jason know he's quite charismatic and he has the ability to captivate an audience. So we're going to do our best to quell that a little bit, like quell the charm. So I met Jason a while back, and we hit it off on truth be told, the restoration of classic cars that maybe 10 or so years ago weren't so desirable. I have a 1978 Datsun 280Z, which everybody says is what their best friend drove in high school. And Jason has a Blazer that blows my Z out of the water. This man's attention to detail told me everything that I needed to know. He brought it over for me to look at it, and I'm just in awe of the amount of work that's gone into this. My very first question to him was, built or bought, right? Did you buy it or did you build it? And of course, built, which man after my own heart. From there, he decided to show me every single flaw on the car, which is a car guy thing, right? You know what I mean? Like, you don't want to, it's like you're afraid they're going to see it before you do. So, you're like, oh, this is that one spot. This is that one spot I don't like. You know what I mean? Which shows, in my opinion, a true level of honesty, right? The coolest thing about this car is the engine swap that he did, and I'll let him go down that path in a future webinar if you guys want to talk cars.
Yeah.
But yeah, I really hit it off with him. I mean, the man is incredibly knowledgeable. I could sit here and read from his bio directly, but I mean, frankly speaking, I think he can describe it a little bit better than I can. So Jason, why don't you give us a little background on how you came to the knowledge base that you have now, which helps
Sure.
in this kind of atmosphere.
Well, thanks, Mitchell. It's great to be part of this webinar. I want to thank everybody at Ship Global IP for inviting me, and I hope we have a good chat this hour. As far as my background, I actually started at the U.S. Patent and Trademark Office. Prior to that, I was a musician and got involved at the PTO. Not only doing standard examination, but I headed up the USPTO's efforts to develop sound mark and motion mark policies. They sort of had them, but there was no real policies in place. And so I really spent a lot of my time there getting to know not just the sort of the examination level of the USPTO, but sort of the agency from top to bottom, dealing with policymakers, dealing with the people in the IT teams at the USPTO, sort of setting these policies in place. And then that once we got sort of sound and motion mark policies set up, there was a lot of cases of first impression that I was sort of the lead voice at the PTO for. So it was a really great experience to learn the agency from top to bottom that I think a lot of former examiners have good experience, but I really got to see sort of the entire process from beginning to end. And so now that I'm in private practice, I'm helping clients to sort of navigate those issues that sometimes you see what the PTO is doing, but you don't necessarily know why they're doing it. And having those relationships and understanding a lot of that can help people, I think, navigate the PTO and not only what they're doing, but why they're issuing refusals or things like that. So that's what we're kind of here to talk about today.
So with the ultimate goal being to make the process more smooth, or make it go more smoothly, and hopefully avoid those things that put kinks in the chain, if you will.
Right.
So with that being said, I'll tell you a little bit about who we are. I'll keep it very brief. We are a company that specializes in the centralization of IP services. We got started about 6 years ago. We focused the majority of our workflows on helping large volume filers find the most efficient methods possible to grant, right? Whether that be, kind of similar to what Jason's saying, like, what can we avoid? What can we do to speed the process up? What can we do to make, not only what we're doing on a a micro level more efficient, but the whole process as it sits. Um, with that being said, we've grown tremendously, and we like to look at things like this webinar as a way for people that we could potentially work with, people that we do work with, to understand that our job beyond just the world of IP filing or whatever it may be, right? Search, trademarks, yada yada. That we're trying to bring value to the table beyond just that relationship. So my name is Mitch Atherton. I'm the Director of Global Strategy. I've been with SHIP since day one. On this call, we also have a few other of our teammates. But from there, I'll let Jason take it over and take you through the Trademark Modernization Act and some do's and don'ts and what we can do to make this process more valuable for everyone across the board.
Great. All right. Do we got the slides here? I'm not seeing them yet, but. Not I can pull them up on my end. Are you muted? I'm sorry, I don't see the slides.
Oh, I'm sorry, I was muting. Yeah, I just made you the, pardon me, I just made you the moderator. So from here, what you'll need to do is just share your screen and you'll be able to go through the slides. Look at that desktop, Jason. Folders, buddy, folders. And Jason, I do believe you're muted right now, just so you're aware.
Okay, I thought we had the slides on your end. I'm sorry about this.
Oh, no worries.
Okay, here we go. Okay. There we go. All right. Does everybody see this? Okay.
Yes, sir.
All right. So here we are. Oh, I want to change this. Well, all right. Yeah, basically, welcome everybody. This is a presentation on the Trademark Modernization Act. We will share these slides after the presentation's over, so feel free. If we kind of skip over one, you can review them, and if you have any questions about them, feel free to reach out to Mitchell and I, and we'd be more than happy to clarify if you have any questions about it. As Mitchell already said, sort of my background at the PTO, I was there for 13 years before coming into private practice, and now that I'm out, I wanted to talk about the Trademark Modernization Act that just went into effect at the beginning of this year. So there are several things that are of note that we will cover, including the post-registration audit program, which is technically not part of the TMA, but is sort of an integrated part that works in connection with it, and what that would mean for people, especially I think if you're a foreign applicant and you're looking to come into the U.S. This is really targeting a lot of practices that come across from the foreign applications. One of the questions that we get most of the time from foreign applications is why is the U.S. so hard on its use requirements? A lot of countries aren't so tough, requiring specimens of use, requiring all these declarations to continually show that you're using the mark. And a lot of it goes back to the founding of our country. The U.S. Constitution has a clause that gives Congress the power to issue patents and copyrights, but it doesn't actually mention trademarks. So for a long time, individual states were seen as giving trademark rights. It was only after the U.S. Civil War that people started to understand there was a phrase in the U.S. Constitution that gave Congress the ability to regulate interstate commerce and commerce between the nations, that people said, maybe we can actually have a federal U.S. trademark right. But in order to do that, they had to regulate commerce as it existed. So one of the requirements to get a registration in the United States is usually to have actual use or be very close to launching use in the U.S. There's no sort of preemptive or defensive trademark registrations like you can get in some other countries, where you can sort of get a trademark registration without having to provide use. Over time, we saw that there were a lot of advantages in the U.S. system, in that if you look at the trademark register, it really does reflect, I think, very well the market as it exists. So if you go onto the U.S. register, there's not a lot of, historically, not been a lot of registrations for marks that really weren't in use. So looking at the U.S. register should, in theory, give you a sampling of what really is out there, rather than having a bunch of trademark registrations that really aren't in use. So that's one of the things that is very important in the U.S. registration system. However, over the last, I would say, 10 to 15 years, growing even larger from that is a system of primarily foreign applicants who I think maybe don't understand how important the use requirements are in the U.S. to just provide, just kind of get trademark registrations. And what we've seen over the last, especially the last 5 years, is there have been a lot of jurisdictions around the world where they might have a subsidy or some sort of incentive to obtain registrations in foreign countries, regardless of whether they have a good faith intent to use that mark. So for some reason or another, there have been just a large number of applications coming into the USPTO for marks that really seem to be questionable. We get a lot of applications at the PTO over the last few years that are just sort of random letters, like this one you see in the slide here, JPJLCN. It sort of doesn't make a lot of sense, but it's kind of clogging up the system. If you look at the filings over the USPTO over the last few years, here's the numbers. If you look at that last bar in each line is the 2021 filings compared to what they were just a few years ago. You've seen that really over the last few years, the PTO was looking at about 150,000 application classes every quarter. Suddenly last year, they were averaging closer to 250,000 a quarter. I mean, that's a 45% increase over what they were doing historically. And when you look at that, that growth is almost entirely driven by foreign applicants. I mean, there's been a little bit of an increase in U.S. Filings, but the vast majority of this growth that you're seeing is coming in from foreign applications.
Jason,
And
I'm going to ask you a
yes,
question right there.
sure.
Would you have any insight as to what you think could be the cause to this uptick in filings?
There's a lot of debate about that, about whether this is just sort of, a good faith attempt to sort of be involved in the world's largest, market in the U.S. That, there are, like I said, several jurisdictions that will provide subsidies to, companies that can obtain IP rights in other countries. So whether it's a good faith thing or whether there's just a sort of a large increase in bad actors that could sort of figure out a way to game the system where they're just filing applications and then can possibly get more money on subsidies or possibly set up fake stores on Alibaba or Amazon because of their trademark registrations. It is a debate as to whether it's sort of a bad faith concerted effort or if it's just actually just a big increase. There's a talk about the increase in people at home in the pandemic, and people, if they haven't been able to go to work, a lot of people have been sitting home saying, well, maybe I'll start my own online business or something like that. So that could be a little bit of a byproduct. Um, it's a very interesting question. Um, but what we do know is the increase in filings has had a dramatic increase in the backlog at the USPTO. I mean, it really kind of came out of nowhere. If you look at the last probably 12 to 15 years, if you filed a trademark application at the USPTO, on average, it took them about 3 months to get around to examining it. It's now over 7 months. We're getting close to the 8-month period where if you file a trademark application, it's taking pretty close to 8 months. So that's having a lot of effect on even domestic trademark applicants. There's always been sort of a timing issue of, okay, you want to get your trademark filed, but you've got to get your product to market. How are you going to time your filing if you know that they're not even going to get it look at it for 8 months? Other issues are if you have a domestic application, you could sometimes apply through the Paris Convention or the Madrid Protocol within 6 months and get a priority filing date in other foreign countries. Well, normally, if somebody in the U.S. would apply for a trademark application, within 3 months, they would know whether the USPTO was going to refuse it or approve it. And then if it was approved, they could go ahead and file their foreign trademark applications under the Paris Convention and get that priority. But now they're coming up on that 6-month deadline, and they don't know if the USPTO is going to approve it or refuse it because it hasn't been examined yet. So it creates a big conundrum for a lot of US filers wanting to know, okay, am I going to base potentially trademark applications on 20 or 30 other jurisdictions on my US application if I don't know the USPTO is going to approve it? So it does create a lot of problems for US applicants, just the pendency.
Thank you.
The other issue, yeah, go ahead.
No, that was it. That was a great answer.
Okay, great. Yeah. And then some of these samples, in the U.S. that you've got to provide actual use to show before you get your registration. Okay, we're going to grant you approval for this mark, but before we grant you the registration, you need to show that you're actually using your mark. So the USPTO, what we noticed in the last several years was a lot of these samples of use looked a little sketchy. They looked a little photoshopped in a way. And so these are some actual examples that we've seen at the USPTO over the last few years of specimens of use that have come in. And then you go on a Google image search and you find, oh, well, this is where they got it. So if you look on the left, each image on the left is an actual specimen of use for, the first one is Becape, and then the sponge is Tulara, and then the headphones are EQEJTP. But you look at the Google image search and you're like, oh, they just took some Sony headphones and they just plopped their own name on top of it. So they're getting trademark registrations for goods and services that they're not actually using. This is also slowing down examination. When I started at the USPTO, we never questioned a specimen. We always just accepted it because the person signs a sworn statement that that's how they're actually using their mark. But so many people were sort of taking advantage of the system that now examiners are having to go through the process of scrutinizing these specimens, looking online to see if they can find where the images are taken from. Here's another example. This is an actual trademark application for tuhujda. And it's very unlikely that someone is actually buying and selling a shirt that is printed like that. So once the USPTO got to the point where they started refusing specimens like this, then everybody kind of gets a little bit more sophisticated. What we're seeing now is people setting up Amazon stores. Here's an example of an Amazon store where they say, well, here's our mark to sell some jerseys. But if you actually go to that Amazon site and you click on add to cart, it usually says product not available, which tends to show that they're setting up a quick Amazon site thinking they can get around the specimen requirement and then going right on to get their registration, but not actually providing any products. So once again, the examiners are having to go through the process of checking all these specimens out.
Jason,
And
if you don't
yeah,
mind, can I ask a question here? Uh,
sure.
have you noticed any pushback from online retailers in this regard?
Absolutely. I mean, I think this is one of the things that you've seen with the start of the Amazon brand registry. Amazon, they didn't want to be known as sort of the place that houses a bunch of fake and counterfeit goods from these shops. So they have sort of taken steps on their own to set up the Amazon brand registry, which you can be a verified Amazon seller if you can show that you have a valid trademark registration. But in some ways, that creates a feedback loop that makes, I think, more people apply for these fraudulent, um, trademarks, wanting to get a trademark registration just so they can get on the Amazon brand registry. So it's something that the USPTO, coordinates somewhat with Amazon to try to, weed out these problems. But it also, I think, creates a even larger incentive for people to obtain trademark registrations fraudulently if they're going to want to set anything up on the Amazon brand registry.
Interesting.
Um, and there's lots of things that the USPTO did prior to the Trademark Modernization Act to try to cut down on this, because you have to understand too, a lot of these applications aren't just random letters. They're not just sort of dead weight. Some of them are legitimate words. If somebody comes in and they file a trademark application for, one example was Pep Boys has Futura tires. Somebody had a trademark registration for the mark Future, and they claimed every good and service under the sun, including tires. They weren't really making anything. It was some, individual that lived in a trailer in North Dakota. But when Pep Boys filed for Futura tires, their application got refused because there was already a registration for Future for tires. So at that point, Pep Boys' only real solution was to file a cancellation action against the owner of this fraudulent Future mark. But cancellation actions they're costly. It's sort of a full-fledged mini litigation. So it's not just something you can file and, within a week or two it gets cleared off. It slows down some good faith applicants. So the PTO knew they needed to do something seriously. And so prior to the TMA, they implemented a lot of new requirements. Probably the most extreme was that all foreign domiciled applicants must be represented by a U.S. attorney. And
Interrupt
so, yeah,
briefly, and I apologize if I'm messing with the flow, but can you do me a favor and turn off presenter view?
sure. How do I do that? Hold on.
Take your time. We're doing great on time.
Better?
There we go.
There we go. Good. All right. I know trademarks. I don't know Zoom presentations quite as well. So sorry about that.
I'm a Teams guy myself. I completely understand.
Yeah, there you go. So anyway, sorry about that. Another thing that they did is if you submitted a website, you had to start providing when you captured it and what URL you captured it from, so that the examiner could go to that website and make sure that what you're purporting to be on that website is actually there. They also increased the authority of examiners to scrutinize their specimens and request more information if they came across a specimen that they felt was questionable. And then the last thing they did right before implementing the TMA was the beginning of a post-registration audit program, which we will talk more about later, and does have some pretty significant impacts for foreign trademark registration owners. But really, why have those steps not worked? Why did we need the TMA if they did all these other steps? Well, like I said, they put in a requirement that foreign domiciled applicants must be represented by a U.S. attorney. Well, guess what? Last year, all of a sudden, there were attorneys that one attorney filed 22,109 trademark applications in a year. Now, I have a pretty robust trademark practice. I don't file anywhere near 22,109 trademark applications in a year. I'm sure any of you that do, you know that that's sort of an impossible feat. If you're actually, representing, scrutinizing, going through and representing that what you're filing is truthful. So it just seems like people have been just sort of rubber stamping, using their bar license to rubber stamp trademark applications for foreign applicants without actually doing their due diligence, doing their ethical duty as an attorney to make sure what they're filing works. So the USPTO is investigating a lot of these attorneys. That's all sort of confidential. I'm sure it will get worked out, but once again, it's clogging up the trademark register with bad faith applications.
Yeah, it seems we're getting a lot of pushback to this act, and maybe people from other jurisdictions as well as our own are looking to kind of break the process.
Right.
Yeah, that's never fun. I mean, because it seems like what the USPTO is trying to do is have a more accurate, like you were saying earlier, accurate depiction of the marketplace.
Right. Right. And another issue is the examiners giving authority to scrutinize specimens. This is an actual example. One of my clients gave me the permission. He had yoga pants, and I actually took this photo myself to show the mark on the pants. The examiner refused this application because they said they noticed there was a wrinkle in the pants, but they didn't see a wrinkle in the logo. So, of course, I called the examiner and I said, well, I took this photo. It's really there. It's not photoshopped on. It just doesn't look wrinkly because the silk screening is more resistant to wrinkling than the yoga pants. But still, they didn't buy it. I had to provide all this additional evidence, and it cost my client quite a bit of money to prepare a response and do things that really they did not probably have to do. So it's still a far from perfect situation to have the examiners sort of scrutinize these specimens so much, because a lot of good faith applicants are getting caught up in this increased scrutiny.
So,
So yeah,
question, if
go
you
ahead.
don't mind going back to the last screen, we actually had a few questions from the Q&A.
Sure.
Number one, have you thought about putting the New York Times in your photos to submit that show a date, show
Right.
what happened, like maybe correlating with the date that you actually submitted the specimen?
I mean, that could work if maybe it's not a website and there is a question about when you made it. I mean, that's one of the requirements now with the website. When you submit it, you have to put the date of capture, and then that way, theoretically, the examiner can check it out and make sure that it was in use when you said it was in use. So, I mean, those are things that, I mean, if there's a way to prove it, and that would involve like I said, the front page of the New York Times, sort of old school, but theoretically that could help if a date ever became an issue.
Tongue in cheek, tongue in cheek.
Yeah, yeah,
Question number two is,
sure.
does the USPTO have anything on the forefront to potentially hire more examiners to deal with the backlog?
Yes, they're planning to hire 100 new examiners this year, and of course that creates another issue. There's a big push to get these new examiners out and examining as fast as they could. Now, when I started there, I mentored under a senior examiner for about a year before I submitted my, issued my own office actions. I think with the demand here and the backlog, they're pushing a lot of these examiners out after pretty much 3 months of mentoring. And it's also having an issue on the quality of examination. Unfortunately, since I left the PTO in 2018, I would say half the examination force is new people, and they sometimes don't have the experience. And so a lot of I think the feedback that you're getting from the outside bar is the quality of examination is taking a hit. And it's not necessarily a knock on the new examiners. It's just that you kind of get good at it after you do it a while. And they're putting examiners out, with very little training, with very little experience. And so it also makes it a little bit more difficult for practitioners on the outside to predict what the USPTO is going to do sometimes, because if your application gets pulled by an examiner who's been doing it for 4 months, sometimes you'll get these sort of off the wall refusals that then you have to sort of call them up and say, hey, this is not how you should be doing this. So, yeah, but there is an effort to increase hiring. I think they have slated 100 new examiners to hire this year, but it takes time to get them trained and into the queue. And so this 8 month backlog, unfortunately, it's going to be around for a while. It's not something that we're going to fix overnight. It's going to take probably a few years, even if they did do enough hiring to kind of eat into that. So
Thank you, Jason.
that's yeah. So that leads to the TMA, and the TMA has 5 main components, which are outlined here, which is identification verification for attorneys, shorter response periods for office actions. You can now formalize a letter of protest. And then the new things that are probably the big deal are reexamination and expungement proceedings. So we'll dive into that. The first thing, and this is a big deal for the U.S. Applicants and attorneys, is we're now going to have to go through an ID verification process. It's now live. It's not mandatory till April 9th, but basically there's a whole process now where you're going to have to scan your ID or your passport. You're going to have to do some facial biometric recognition. This is really to prevent, we talked about that attorney earlier who filed the 22,000 applications in a year. I'm sure he's saying, well, somebody hacked into my account. I didn't do this. Somebody did it. Well, this is designed to prevent that. That way, when you log on to the USPTO system, you're going to have to, provide facial recognition, a social security number, credit check. That way, they know the people who are signed on are the people who say they are. Now, I think this is going to have a couple of things. Is it's more time and money for every time I log on to the USPTO, there's a new 5-minute process that I didn't have to go to before. So, when I'm filing a new application for a client, I have to take that time into account. If I could get an application filed in X amount of time, it's now X amount of time plus 5 minutes. So, that's going to have to be factored into the cost of everything you do on the PTO, not just filing an application. It could be a renewal. It could be a change of address, anything like that. You have to go through this ID verification process to get on. So that's going to, all in all, increase the time and effort and cost of doing anything with the PTO. The other question I will have is, as of right now, U.S. applicants don't have to be represented by an attorney to file an application. Are U.S. applicants going to go through this sort of onerous verification ID process to file their own application? Or does that mean they're all going to just say, well, Jason Blair, all the other trademark attorneys I know, they're already set up. I might as well just use them for filing. So it'll be interesting to see what the effect is on what we call pro se applicants, applicants who aren't represented by an attorney. The other issue is response deadlines. Traditionally, you've always had 6 months to respond to an office action in order to kind of cut into that backlog and the time it takes to clear off applications, they are shortening that time to 3 months. That goes into effect in December. So this is a big change for a lot of people. Now, one thing you can do is buy the additional 3-month period for $125. So, you can keep that 6 months if it's something where you just really need a lot of time to get your evidence and your arguments in order, but you have to file a request to extend it and pay the additional fee. Interestingly, applications that come in through the Madrid Protocol are exempt from the 3-month shortening. They still have a 6-month response deadline. I know a lot of attorneys were very upset about this because they always said, well, man, I can't even get my client to respond when we've got a 6-month deadline. How am I going to get them to respond when we have a 3-month deadline? I think you can kind of embrace this. This is something where, in my experience, a lot of times we'll get an office action. I'll tell a client and they'll say, great, when do we need to respond? And I'll tell them 6 months from now. So what do? They immediately put it on the back burner because it seems so far down the road. They're worried about the next quarter. They're not worried about what's 6 months down the road. So it's not until you get to like 5 months that then everybody's scrambling. Using the 3-month deadline, I think, can keep your clients a little more responsive. You get an office action, you're like, hey, we got an office action. We've only got 90 days to respond to this thing. That way, they're more likely to keep it up front, keep it in mind, and then that way you can kind of maybe get rolling on it. So I think it could be a plus. But you'll have to keep that in mind that with these shorter deadlines, there are a lot of applicants that sometimes will file an intent to use application knowing that they're not going to be hitting the market for years and years. A lot of it happens with pharmaceutical applicants. They want to get a trademark, but they've also got to get FDA approval, which could take years and years. So they sort of like slow rolling their application. They don't want to apply and then get hit with the, okay, everything's approved. Now you got to have it to market before we'll grant you registration. They like having that long time. So you need to make sure you're timing your applications, because theoretically, if you've got a shorter deadline to respond, you're not going to always be able to count on office actions to sort of extend that time you can get your product to market. Another thing you'll want to do is monitor blocking applications. A lot of times when you file an application, if somebody's got a similar mark ahead of you that's not registered, they will suspend your application for 6 months to see whether that application ahead of you either abandons or is approved. Well, now that you've got a 3-month response deadline, it's kind of up to you to maybe keep track of the blocking mark. Instead of just waiting for that 6 months to roll around, check it in 3 months. And if they haven't responded, then you can say, hey, this one didn't respond. That one's abandoned. Let's go ahead and get rolling on our pending application, take it off suspension.
Jason, we have a pretty good question
yeah.
here that I think deals with this deadline mitigation issue. And this comes from Heidi. She says, I'm a paralegal for a corporation who prepares the filings. How do I get sponsored to be able to continue to file for the owner?
The attorney, you have to be sponsored by an attorney. That's definitely an issue for, I know there are some paralegal firms out there. They're going to have to partner with a sponsoring attorney. The attorney is the one whose sort of license is on the line. So that's the paralegal would then operate under the attorney's ID verification. So if you don't have an attorney you're partnering with, start making some friends. that's what I could say.
Thank you.
Yeah. The next thing is, this is something that's always been available, but it's always sort of been an informal issue, is a letter of protest. Now, what a letter of protest is before a mark is approved, if you see somebody apply for a mark that maybe you have a problem with, you feel it's either descriptive or you feel that it's too similar to your mark, you've always been able to file a letter of protest with the USPTO. But there was no real formal procedure for it. It was just sort of a short little write up where you could say, hey, this is why I have a problem with it. Just take this into account when you're examining. Under the Trademark Modernization Act, it is now a formalized procedure. You pay a $50 fee, and when you file it, the USPTO has 2 months to review it, and the commissioner's office will look at it. They think that if it seems like it's relevant, they will then forward your letter of protest to the examiner who's assigned to that application. Now, if the commissioner feels that your letter of protest is not relevant, there is no way to sort of appeal or review or challenge that. It's pretty much just up to the discretion of the commissioner. Now, at one point, what I would advise is I would have this a lot as an examiner, where people would file a letter of protest, and then they would sort of want to follow up with me as an examiner to make sure that I got it, and that they wanted to talk it through. You have to remember, this is an ex parte proceeding. You are not actually part of this. You're not a party to this. So it's actually improper to contact an examiner directly about an application that is not your own. You don't want to do that. If people would call me when I was an examiner and they would say, hey, I'm calling you because you're the examiner on this and I have a problem with it, I would just say, I'm sorry, but I can't talk to you, and hang up. You don't want to be in a situation where you could be accused of sort of unduly influencing an examiner. So really, if you file a letter of protest, this is your way to do that. You just don't follow up, don't make calls, because then if you did want to enforce, you could actually be in trouble for sort of an ethics violation there. Also, when you file a letter of protest, the last thing as an examiner I would want to get is, 100-page letter of protest with just all this evidence, and you're literally litigating the thing like you're in a full court litigation. As an examiner, the examiners don't have time for that. They be as concise as possible. Make your points on as few pages as you can. You're going to make friends with the examiner much better than if you load them down with a bunch of stuff that they're going to have to wade through. So don't do that. Those are sort of my tips on the letters of protest. Which then leads to, I'd say, the biggest part of the TMA is a new procedure for expungement and reexamination. Now, this is very interesting in that it allows parties to challenge a registered mark without filing a formal cancellation proceeding. So the thing that you need to remember here is, I think a lot of people look at obtaining a trademark registration as the finish line. Like, oh, I got my registration, I'm good. The registration really should be your starting line, because once you have a registration, it doesn't mean that you're not going to be defending it. You're not going to be questioned about it. People will be able to challenge your registration if you are using it. You're claiming more goods than what you're really using it for. So this is a new procedure which allows a company, say there's a party out there that has a registration for every good and service in class 25. They're claiming every type of clothing in their registration, and you look and all you can find is they're using it on socks, and that's literally all you can see them using it for. Instead of filing a cancellation, you now have the ability to file either an expungement or reexamination request with the USPTO saying, hey, we did our research. We can't find them using this on anything except socks. Can you look into this more to see if they really are using it on all the goods and services that they're claiming? So there's a slight difference between expungement and reexamination. Expungement is you're alleging that the registration owner never used the mark at any time for the goods that you're claiming. And so if they've got a registration and it's been 3 years and it's been registered, and they have blue jeans in their registration, and you've saying they've never used blue jeans. We can't ever find it. You can file for an expungement. Reexamination is a little bit different, where within the first 5 years of a mark being registered, if you look at their specimen and you're like, I don't think they were really using it at that point. They weren't using it on the date of use that they were claiming they were using it. Then you can challenge it on that ground. So those are slight differences. Expungement is sort of after 3 years. Reexamination is within the first 5 years. The way it works is you're not really a party to it. It's not something, whereas a cancellation, you're submitting your briefs, you're arguing, you're a party to the proceeding. Expungement and reexamination, you're letting the USPTO do the work for you. You pay a $400 filing fee. You write a letter saying why you feel the registration in question, they are not using the mark in the way they claim to be. It needs to be signed by a U.S. attorney or a recognized Canadian agent, saying that you've done a reasonable investigation, and then you provide a copy of the evidence of your investigation, saying this is what we looked into. We can't find them using this, and these are all the stores. We went to their website. We went here, and can you look into this more? At that point, the USPTO takes the petition, they load it into the record, and they notify the owner of the registration, hey, somebody's filed a petition against you. However, at that point, the registration owner does not respond at that time. What happens then is the director of the USPTO then looks at the petition to see if an actual case has been made that maybe this registration is claiming more than what it's actually being used for. If so, then the director can initiate the proceeding. Also, the director can initiate a proceeding on his own, even if somebody does not file a petition. So the director can just say, hey, this looks a little fishy, and initiate an expungement or reexamination. Once that reexamination or expungement proceeding is started, then the USPTO is in control. They drive it. So what happens is they will issue an office action to the registration owner saying either the director or another petitioner is claiming that you are not using your mark on whatever goods are being called into question. And we need you to provide us with evidence that you are. So at that point, just like any other office action, the registration owner has 3 months to respond to provide, oh, no, see, we actually are. Here's our website. Here's our product. Here's our service. Here's the evidence that we're actually using it. So you have 3 months. You can request a 1-month extension for $125. But if the registration owner does not respond, then the mark is canceled. And then if they do respond, but the evidence still seems a little shaky, then the USPTO can issue a final office action, at which point the registration owner can either file a request for reconsideration or appeal the decision to the TTAB.
Sorry, just to pop in here for just a second.
Mhm.
As you were discussing earlier, and maybe this was offline, but how other jurisdictions will file their applications and then try to gain coverage in the United States. You mentioned here that it could be canceled either fully or partially as appropriate. Right. Is this an instance where some of those other claims could be potentially wiped out and just what they're actually using would be in force?
Right. Yeah. I mean, if you've got to simplify it, you've got a registration for forks, knives, and spoons, but you're only using it on forks, and you could provide evidence of forks, but you can't provide it for knives and spoons, they might just cancel it. They just remove knives and spoons from your registration. You could still maintain your registration for the goods that you were actually using it for, but it's still a big headache to prove all this stuff. And I think what the lesson here is that you've got to think about what's in your registration. A lot of times, and this is where it's really important. In a lot of countries, you sort of get this class-wide coverage, and I think that there's a thought in a lot of countries to just sort of claim everything in a class. We're paying for class 9. Let's just throw it in, and then you get a registration with a big laundry list of goods in class 9, even though you're probably only making 10 of those things. So you're really opening yourself up to problems on the back end if you've got these registrations that are long laundry lists. And also, I think what a lot of companies do is they know that their renewals are up every 10 years. They kind of just they audit what they're actually using the mark for every 10 years. They're rolling around, oh, we got a renewal. Are we still using it for all this? Well, you kind of have to stay on your toes all the time now. I would say yearly, you need to think, okay, are we still making this product? Because that happens over time. You cancel a product, but you've got a registration for it. You might want to actively be thinking about, okay, do we need to remove this from our registration? Because we could get called on this at any time. And if we get called on it, all of a sudden we're in the middle of this big expungement reexamination procedure. You don't want to be sort of the party that's seen as a usual suspect. If people call you up, you lose 3 or 4 of these, you're kind of going to get known for a reputation of, oh, well, they overclaim, so we're gonna file more of these. You don't want to have that reputation. You want to be seen as more active and removing the things, proactively, that you're no longer using a mark for. So those were tips I would say that you would want to keep in mind. The other issue that we're sort of dealing with is we'll have to see. The USPTO says they have procedures in place to prevent sort of bad faith reexamination filings. Like, I think there's this fear of, like, maybe a former employee doesn't like the company, so he just keeps filing reexaminations. Okay, they're not using it for socks, and now I'm going to file another one that they're not using it for pants, and now I'm going to file another one they're not using it for gloves. And it's $400 out of pocket each time for that person, but it costs the company several $1,000s to respond to each one of these. So there's the PTO has said that if there are sort of almost like a challenge flag in football, if you challenge so many of them and they're not successful, they might prevent you from filing more of them. But how that's going to work in practice is still remaining to be seen. So anyway, and then the last thing I will say that is a big issue is the post-registration audit program. The post-registration audit program is a situation whenever you've got a mark come up for renewal or a declaration of use. The USPTO is now running a system where they run all these registrations through an algorithm, and they look to find basically foreign applicants who claim a lot of goods and services in their registration. And so when they come to renew, they say, hey, prove to me you're using this and this. And the examiner will go through and try to find sort of oddball entries into your ID. Like if you've got a lot of software in class 9, but then you've got cash registers in class 9, they're going to say, well, cash registers doesn't really fit with software. So prove to me you're using the mark for cash registers. Well, if you can't, then they will say, okay, you didn't pass the audit. You've now got to prove to us you're using the mark for everything in your description, every single thing. So if you have 80 things in your registration, you have to prove use for all 80. So it's really a situation where I think coming in with a foreign style, broad laundry list registration. Like you see them, they'll say computer programs, computer software, computer application, computer platforms. You're racking up this big laundry list of goods that maybe just saying computer software would be enough to cover you in the US. So in some ways, you could be saving money by not having a US counsel look at your application before you file it in the US, but you're costing yourself money in the back end because you're really going to run into these audits, and it's going to cost a lot of money in the long run. So really, I think the smarter thing is to, if you're the type of company where you usually just take your foreign, your, EU registration or your Brazilian registration, and you just, port it over to the US and use the same description of goods and services, you're really creating problems for yourself in the long run. It's better to maybe have a US counsel look at it and say, hey, let's narrow it down to your core goods and services. That way, you're less likely to get audited. And in the event you do get audited, you're going to be able to show use for what they're calling you on. So I'd say that's a really big takeaway, all in all, from the TMA is you don't want to see a registration as an end goal. It's not just, okay, let's get a registration and we're good. You want to make sure that it's correctly claiming the goods and services that you can show use for. Don't overly make your descriptions broad, overly worded, make them as concise as you can be, because it's really going to save you a lot of time and headache in the long run. So that's kind of the summary of the TMA. If there's any questions that we want to cover at the end.
Well, Jason, yeah, we do have plenty of questions actually, but I would like to
Okay.
first and foremost thank you for bringing your knowledge to the group. One of the things that we like to do here at SHIP is pick our partners very, very carefully. And if this does anything, it shows that the people that you'll be working with when working with us have a deep intrinsic knowledge of their area of expertise. With that, let's go into some Q&A.
Okay.
So we had a lot of questions excuse me, good Lord. we had a lot of questions as it related to expungement and reasonable investigation. So I'll start with the first one, which comes from Megan Cope. She says, for expungement, can that only be initiated after 3 years?
Yes. It's anything prior to 3 years. The reason for that is you've got a lot of countries where you've got sort of a 3-year mark to have use after registration. Well, some of the foreign registrations that applications are based on, if you think about it, if you're a domestic applicant and you file an intent to use application and you get approval, you can keep filing extensions for 3 years to get your product to market. So you've technically got 3 years from a notice of allowance to registration. Same way with a foreign applicant coming in, we obviously don't have a notice of allowance for foreign applicants if they're based on a foreign registration, but we give them sort of a 3-year grace period to say, okay, you've been given approval to use your mark in the US. 3 years seems like a reasonable amount of time that you can ramp up your activities and get out into the market and actually start using it. So anything prior to 3 years, you'd have to be looking at the reexamination procedure where you're saying they lied about what they were using the mark for at the time of the registration.
Okay. So the next comes from Lawrence Hoffman, and it says, what type of investigation are we supposed to do to qualify for reasonable investigation?
That's a good question. There haven't been, I think the first pair of these proceedings have been filed in the last, it just went into effect at the beginning of the year. So there hasn't been like a lot of case law on what the minimum requirement is. And obviously it's hard because you're trying to prove a negative. You're trying to prove sort of lack of something. So I think it's going to be interesting to see what standards the USPTO holds. But, I think the idea at the very minimum at this point, until we get some more robust case law, is anything that you would sort of reasonably do. You can't just say, hey, I went to their website and I don't see it. Because there are obviously people have websites and they don't put everything they have on it. But if, showing, okay, we went to an Amazon store, or we, if they've got a physical location, I don't think it requires you going to every single store they've got nationwide and checking every counter. But it's just sort of, if you went to the major retail sites, you went to their website and don't see any mention of these products, that's usually probably going to be enough to start an investigation into this.
Okay. So the next comes from Grace Jennings, and this actually is from a little bit early in the presentation. My apologies. Do you need to have a similar mark or registration to the mark that you are filing for expungement or reexamination against?
You actually do not, and that's one of the interesting things. You don't actually have to say, well, this is why we are questioning this. It's in fact, if an attorney files it, at first they don't even have to identify the client on behalf they are filing it on behalf of. So theoretically, you could maintain a little bit of anonymity if you're filing a reexamination or expungement. They'll know who the attorney is, but they won't necessarily know who the attorney is filing it on behalf of. Now, the director, if he feels that that's fishy, can ask the attorney for the identity of the party, but that's not actually a requirement of filing. So you could do it sort of under the radar. Like if you're a company, maybe you're planning to file an application, but you don't want anybody to know about it yet, but you see a blocking mark that you want to clear off before. You could theoretically file a reexamination or expungement without having to have a mark already filed.
So I like this question. This comes from Lynn Harris. And the question is, does evidence of use have to predate your expungement slash reexamination request? If not, the mark owner could simply forge it.
Yes, for a reexamination, that's the question: is were they using the mark at the time they signed their declaration that they're using their mark? So for in the U.S., you sign a sworn statement that you are at the time you sign it using the mark at that date. So if somebody files a reexamination proceeding against you and it's 2 or 3 years later, the question is, can you prove you were using the mark back when you signed that declaration? So it's not something that you can go and fix sort of after the fact. They would need dated, like you said, if you want, you get your New York Times photo out, something like that, show the date that it was actually proved. So
I'm a solutions guy, I'm
right.
like, how can we get around this? The next question comes from Claudia Gonzalez. She says, in Mexico, it is still allowed to indicate as a good, for example, software, but this is a broad product.
Mm-hmm.
And the applicant could be using the mark for any type of software and still claim that it's being used. Does the USPTO allow this type of wording, such as software or cosmetics,
No.
for example?
At one point they did. There are some old registrations in the 90s that are still existing for just software. And it's kind of annoying because, it's like an accounting software. And then, you'll get an applicant today that's doing, kids video games but you have to sort of treat it as if the registration covers all software. But no, today the USPTO is much more specific on what they require for a description of goods and services. And that's mainly just because the market here is so large. Some other countries, if their GDP is just a fraction of what it is in the US, you can sort of have one company owning a mark in a large field. But in the US, if we granted every company just the ability to own software, there'd be so many that pretty soon you'd run out of names. So really in the US, they do limit it to, you have to say it's accounting software, or it's software for global positioning, or whatever it is. You have to sort of say what the function of it is.
Okay. And our last question comes from Ruth Thompson, and it's, how does it work with the Madrid Protocol applications? They typically have a laundry list of goods that are extended in the United States. And they don't show use until the time of file, excuse me, they don't have to show prior use until section 8 and 15.
Right.
Has that changed with the TMA?
So the TMA would, excuse me, that would be a situation where the expungement could come into a play, where if you've got a trademark it came in, it got registered through the Madrid protocol. It's got a long laundry list. They've never shown use. But then, the 8 and 15 is not due until the 6th year after registration. Well, the expungement could call into question that mark after 3 years. So 3 years after registration, someone could come in and say, hey, they're not claiming it, they're not using it on half the things in this registration. So that would be the procedure that would allow people to sort of clear off marks prior to that 6 year 8 and 15, or technically for Madrid it's an 8 and 71, but it's pretty much the same thing. But that would be the procedure, the expungement procedure.
And just so everyone's aware, we instructed Jason specifically not to give away his special sauce. He had a lot of really interesting tidbits in this presentation that, in my opinion, come from his many years of expertise. And working with someone like Jason, or working with someone like us, in order to utilize Jason, if you're coming from the foreign into the U.S. as a jurisdiction, gains you entry into that special sauce, if you will, which I promise you is much more in depth than what was the McDonald's special sauce? It was French dressing and mayonnaise.
Mm-hmm.
Something like that.
I'm a sweet and sour guy, but hey.
Well, Jason, we would just like to thank you very much for your time this morning. I feel like this was a very informative and helpful presentation. You've been a wonderful partner to us, and we wish your practice the absolute best. Thank you to all the attendees who have come out today, whether you're our partners in other jurisdictions or counsel in the United States. We value you, and we hope to bring you more content like this in the future. Of course, we have recorded this session, and we will be posting a blog post with the broad strokes of questions here that we thought were answered quite well, but there will also be a link to the recording if you'd like to share it amongst your colleagues. And with that, I will allow you guys to get back to your day. And once again, thank you so much, Jason. Yeah, that's that.
Thank you. Appreciate it. Thanks, guys.
Well done. Y'all have a wonderful day.
Mm-hmm.